Briefly address before we bring the jurors in. The first concerning the waiver of attorney-client privilege as to the testimony of Ms. Descalzo. I am going to need to place the defendant under oath concerning this. Ms. Adelson, please rise, raise your right hand. Raise your right hand, please. Do you swear or affirm the testimony you're about to give will be the truth?
Yes.
You can lower your hand. You understand with your former, or I guess I don't know the relationship exactly, but someone who has previously represented you, concerning their testimony today, are you waiving attorney-client privilege concerning what they will testify about?
Yes, I am.
Concerning that, Mr. Zellman, do you wish the court to make any further call, please?
Yes, Your Honor. The waiver is specific as to the counsel that our client received from Ms. Descalzo.
Well, if you need to discuss with her what she's waiving, that's fine. I don't believe you can waive on her behalf. Mrs. Adelson, do you understand the scope of the waiver that you're providing? Do you understand the scope of the waiver that you're providing of attorney-client privilege?
I do, Your Honor.
What is that scope?
The information that we discussed after my son's trial regarding my travel and my state of mind.
Is the defense planning to examine this witness on any other topics than what has been identified as the scope of the waiver?
No, Your Honor.
Very well. If any matters are inquired into that exceed the scope, at that point, we are going to have to send the jury out of the room. As I previously stated before, the state is permitted to cross-examine as to all topics that are inquired to on the defense direct, and also as well matters of impeachment and bias. Does the state need to be heard in any way?
No, sir.
As to the other matter concerning whether Mrs. Adelson will testify as a part of the defense case in chief, Mr. Zellman, were you able to speak with her as to a final decision?
I'll allow, the short answer is we were allowed 20 minutes during the lunch break to speak with Ms. Adelson.
In addition to the time that you had yesterday and other times?
Yes, Your Honor.
If I may, Judge, the issue is that we...
Well, one moment. Who's handling this matter? We're not tag teaming any arguments of any sort.
Your Honor, what Ms. Fulford and I have discussed was the factual issues that are concerning our client's decision. She was more involved in than I was. So the only thing that I intended to address was the time that we had during the lunch break. Aside from that, I'm asking that Ms. Fulford be allowed to address the court.
Ms. Fulford, go ahead.
The issue that we're facing, Judge, is this was 6 days of testimony from witnesses for the state and a great deal of evidence that they have entered. We have discussed with our client, of course, her right to remain silent or whether she wants to testify or not. We have not had an opportunity to go through all of the evidence that's been entered in this case and have a full and frank discussion with her about that evidence. If there are any issues that she thinks need to be addressed for her testimony, whether she thinks she needs to testify or not, and what her decision is on that.
When we had the break yesterday at 2:45 in the afternoon, you did not speak with your client concerning whether she wished to testify or review the evidence?
Yes, Judge, and that's what I said. We have discussed with her whether she wants to testify or not.
The defendant in every single case, Ms. Fulford, is faced with this moment as the defense case in chief ends. What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Yesterday, when you allowed us to recess early, Judge, Mr. Zellman and I spent time going through the evidence that was admitted, making sure that we understood everything that was there, because there was some confusion during the trial about things being added and things being removed, so we wanted to make sure we understood completely what there was there. We left here, went straight to the jail, and had the issue with the potential new witness and spoke with our client. But that's not an ample time to discuss with her what has actually come in the state's case.
Your client is in a no different position than any other defendant who has to decide whether they wish to testify or not. I will give you 5 additional minutes to discuss this matter. From there, the defendant is going to have to make a decision of whether she is going to testify or exercise her right to remain silent. Please check with the jurors, let them know that we will get started momentarily. Okay.
Times is the response from the audience concerning things that are said by the defense. And although the proceedings are public, that has not stopped the peanut gallery from their comments and laughter. We are respectfully requesting that the court allow Ms. Adelson to participate at sidebar as she is entitled, and for the court for us to address additional issues that are weighing on Mrs. Adelson's decision.
Please approach. We are not going to do this for very long. Everyone can be seated. Members of the jury, I hope you had a restful lunch break. We are going to continue at this point with the defense's case. Please call your next witness.
Before we call our next witness, we laid the foundation through Luis Rivera for Defense Exhibit 50. At this point in time, we'd like to introduce that into evidence.
Any objection from the state?
No, Your Honor.
Defense 50 is admitted.
Thank you. At this point in time, the defense would call Marissel Descalzo.
Please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth?
I do.
You may be seated.
Thank you.
You may inquire.
Thank you, Your Honor. Good afternoon, ma'am. Can you please introduce yourself and spell your last name for the jury?
Marissel Descalzo. My last name is spelled D-E-S-C-A-L-Z-O.
And Ms. Descalzo, can you tell us how you're employed?
I'm an attorney,
Okay, what type of attorney?
a criminal defense attorney,
And how long have you been practicing?
since 2003.
During a period of time ending shortly after her arrest, did you represent Donna Adelson?
Yes, I represented her sometime in 2022 through maybe 3 months after she was arrested.
Okay. And I want to direct your attention specific to the late October and beginning of November of 2023. During that time period, was her son on trial?
I'm not sure about the dates, but it sounds about right.
Okay. During that time period, when her son was on trial and shortly after, did you have some concerns based on statements that she was making?
Concerns about Mrs. Adelson's mental state, yes.
Yes. Can you tell us what those were?
She had made numerous statements about terminating her life if her son Charlie Adelson was convicted.
Did that cause you to take any steps or actions to determine what you needed to do?
Yes.
And what were those?
Well, first, I conferred with Daniel Rashbaum, who represented Charlie Adelson. So we discussed it, and we decided that we needed to call Ethics Council and call the Florida Bar to determine if we needed to take any additional steps, such as Baker acting her, or Baker acting as putting her in a mental institution, or anything else.
Okay. After doing that, did you have further discussions with Mrs. Adelson about her mental state and what she was going to do to try to clear things up?
Mr. Rashbaum and I spoke to her further, and, you know, she told us that what she really wanted to do was she wanted, you know, to get away on a vacation with her husband. Her husband agreed that this would be good for her mental state, and so we discussed a potential vacation.
Okay. At that point in time, was there anything preventing Mrs. Adelson from traveling?
As far as Mr. Rashbaum and I knew, there was not.
Okay. And specifically, there were no warrants for her arrest?
My understanding from speaking to Mr. Rashbaum, that Mr. Rashbaum had communicated with law enforcement and that there was no outstanding warrant. I had been in touch with the prosecutor of this case, and I apologize because I only remember your first name, but with Georgia. And we had discussed previously, not around this time, we had previously discussed that I represented Mrs. Adelson, so I assumed that if anything would happen, that if there was a warrant or if Ms. Adelson was going to be arrested, that I would be contacted.
Did you advise Mrs. Adelson that if a warrant was issued, that you would provide her with that information so that she could self-surrender?
So the discussions I had with Mrs. Adelson weren't exactly like that. Mrs. Adelson discussed what would happen if there was an arrest warrant, and the potential things that might happen. The prosecutor had never guaranteed for me that Mrs. Adelson could self-surrender.
Okay. Did you tell her did you tell Mrs. Adelson that self-surrender was something that could happen?
Yes, I did.
Okay. And on November 6th, her son was convicted. Did you speak with her after that, specific as to her ability to travel?
I don't remember the date, but there was discussions about her traveling after the conviction, because around that time was when she was making the serious threat, was when Mrs. Adelson was making these serious threats about her life.
Just a moment, Your Honor. Nothing further, Your Honor?
Cross-examination.
Yes, sir. Good afternoon.
Good afternoon.
Now, if someone has a warrant, is it up to the defendant or the suspect, the person who has the warrant, to dictate their terms of surrender?
I don't think so. It's up to the law enforcement.
It's usually up to law enforcement to decide how or where to apprehend that person, right?
Yes.
But, so it's not a requirement of law enforcement to notify someone when they have a warrant, but that is sometimes a courtesy that's extended, is that right?
That's correct.
And that is a courtesy that's sometimes extended in situations where, let's say, someone is not a flight risk, right?
It's in all sorts of situations you can have self-surrender extended to. I wouldn't limit it to only people that are not a flight risk.
Okay, would that be one situation?
I would assume so, yes.
Okay. And you were told that by Georgia, by Ms. Kappelman, that you wanted to know whether she had a warrant, she could turn herself in. That was some amount of years ago?
It was definitely before Charlie Adelson was convicted. It was on a phone call that I had. I offered it, and as I stated, Georgia Kappelman did not guarantee that.
Okay. But that was before Charlie's trial or verdict?
Correct.
After the verdict, or I guess during the trial or after the verdict, did you disclose to anyone in the state attorney's office that Ms. Adelson was suicidal?
Of course I didn't.
Okay.
No, I had an attorney-client privilege relationship with her, and I don't think that would have been appropriate.
Sure. And why was she suicidal?
Because her son had just been convicted, and she was worried he was going to spend the rest of his life in prison.
Was she also worried about getting convicted herself?
I don't believe that was even crossed her mind. She was only worried about her son.
Okay. Are you aware of a text message where she said that she was afraid she was next, but don't worry, she would take care of that?
I'm not. I'm sorry. Was that a text message to me, or?
I don't believe so.
Yeah, I don't have any knowledge of that.
Okay. At the time of, were you present when Dan Rashbaum told her that she may make it to the airport in time, or she may get to the airport and not be able to make it out?
Mr. Rashbaum and I don't believe that was a telephone call. I don't believe that was in person. And I was on a call, and I myself also told Mrs. Adelson that we did not know whether there was, that we understood there wasn't a warrant, but that didn't mean she couldn't get arrested at the airport.
Okay. When you suggested, I guess, was the suggestion that you said that she take a vacation?
I don't believe I suggested it. I believe that that's something that was being discussed between Mrs. Adelson and her husband as something that would help her with her mental state.
Okay. So that's something they suggested, but not you?
Correct. I did not suggest that they take a vacation.
Okay. Did you know at the time that the vacation that they were suggesting, they were considering Vietnam, China, or Korea?
I did not know the location of where they were going.
Okay.
And it was never discussed with me.
So at that time, you didn't have knowledge that they were specifically looking for non-extradition countries?
I did not know one way or another where they would vacation to.
If Donna Adelson was overheard by law enforcement debating between either committing suicide or fleeing to a non-extradition country, do you think that would change law enforcement's stance that she could turn herself in?
Objection, Your Honor, calls for speculation.
Overall, the witness has opined on this matter.
I'm not law enforcement, so I'm not sure, and I've never been in law enforcement, so I'm not sure.
I can rephrase it. Would you expect that to change the stance?
If I was law enforcement and I heard a target of investigation discussing a flight.
As her attorney,
Okay.
would you expect if she's overheard debating either committing suicide or fleeing to a non-extradition country that she wouldn't be expected to be able to just turn herself in on a warrant again after that?
I don't know. I think it would take, to be honest with you, I'm a criminal defense attorney, so it would be case by case. Probably that would make the bond hearing a little bit more difficult if those conversations were overheard. But every prosecution is different, and maybe the prosecutor would agree. I don't know.
Okay, 1 second. Specifically, though, about self-surrender, would you expect that to change law enforcement's stance as to self-surrender, not as to a bond?
Again, I think that that's specific to each case, and I don't know exactly what was overheard, so I apologize, but I don't really have a concrete answer for you, other than what I said before, that it would come up at a bond hearing.
Thank you.
Redirect examination.
Thank you, Your Honor. Mr. Descalzo, prosecutor asked you about fleeing the jurisdiction. My client talked to you about a vacation, correct?
That is correct. It was not fleeing the jurisdiction.
And the state also asked you about fleeing or going to a non-extradition country. Have you, in your career, dealt with extradition from foreign countries?
Yes, I have.
And merely because someone is in a non-extradition country, does that prevent the United States from attempting to seek their return or their extradition to the United States?
It absolutely does not, especially if you're a U.S. citizen.
Nothing further.
You may step down. Is this witness going to be recalled for any purpose?
No, Your Honor. I believe she might be able to get the early flight this evening.
You are released.